trial is like a story, where each witness tells a portion of the story to the jury, otherwise known as the trier of fact. This is done through two types of questioning: direct examination and cross-examination. When an attorney is questioning their own witness that they have called to the stand, this line of questioning is called direct examination, sometimes referred to as direct for short. When the opposing counsel is questioning that witness, this is called cross-examination, or cross for short. Direct and cross-questioning are very different.
Direct examination questions are conversational and open-ended. They allow the witness to tell their story in a series of questions and answers. The questions usually begin with foundation questions regarding who this person is and what is their relationship to the case. They may be asked to state their name and occupation and explain how they came to be involved in the situation. If they're an expert, like a doctor or a forensic examiner, they may be asked about their credentials so that they can be qualified as an expert witness. After the attorney has laid the foundation, the attorney can't just then say, "Now tell me what happened that day," and let the witness ramble on and on. Instead, one question should naturally lead to the next, picking up where one leaves off, and bringing the jury along as the story develops. One of the most common mistakes during direct examination is called leading the witness, and it's not allowed during direct. This is when the attorney suggests the answer while asking the question, such as, "Isn't it true that you wore your blue jacket that day?" The witness just has to say yes, because the attorney gave them the answer. The reason this isn't allowed on direct is because it would be far too easy for an attorney to put anyone on the stand who can say yes to everything and let the attorney testify. Objections are explored in more detail in the objections video.
Please state your name and occupation for the court.
Yes, my name is John McLean, and I'm a detective for the Dallas Police Department.
And how long have you been a police officer with the Dallas PD?
I've been an officer of Dallas PD for about 7 years now.
Were you working on the night of October 12th?
I was.
And anything significant happen on the night you were on duty?
I answered one call for service that ended up being a major accident call.
And when you respond to that, can you explain for the court what happened during that response?
Yes, I arrived at the scene of the crash.
Cross-examination is more adversarial. It takes place after direct examination, when the opposing counsel has the opportunity to question the witness. It's less friendly and more controlled. The attorney should ask close-ended questions that don't allow the witness much, if any, wiggle room. Questions with a yes or no answer are best. The idea is to paint them into a corner, poke holes in the witness's story, or make them not look credible. During cross-examination, leading the witness is not only allowed, it's good practice.
Officer McLean, isn't it true there were 2 cars involved in the crash that evening?
Yes, ma'am, there were.
And when you approached the scene, you questioned the driver of the first vehicle, isn't that true?
Yes, I questioned the first driver.
Okay. The driver of the second vehicle was transported by ambulance to the hospital, is that correct?
Yes, they were.
And is it my understanding that you and your partner made your way to the hospital to question the driver of the second vehicle?
We did. We went up to the hospital.
And were you able to question the driver of the second vehicle?
No, we were not. They were not physically and mentally able to answer questions.
It's true they were unconscious, correct?
Yes, to my understanding, that's what the doctor said.
And so you were not able to take a statement from the driver of the second vehicle involved in this crash. Is that right?
Correct. We did not get a statement from the second driver.
Officer McLean, isn't it true that you also neglected to follow up with the driver of the second vehicle? Yes or no is fine.
We did not follow up and get a statement from the second driver.
So at no time during your investigation did you actually speak to the driver of the second vehicle?
That is correct.
After direct and cross-examinations have concluded, the side doing the direct questioning has the opportunity to redirect. This is the opportunity to ask their own witness a couple of follow-up questions to reiterate the witness's credibility or undo some of the damage that may have been done on cross-examination. Redirect is not the opportunity to ask questions you forgot to ask earlier. The questions can only relate to what came up on cross-examination. Otherwise, the other side will object and say they are beyond the scope. See the objections video for more clarification on this point. If the attorney does ask redirect questions, the opposing counsel has the opportunity to ask recross questions, but the same rules apply. Attorneys should keep it short and stick to what only came up on the previous line of questioning.
There's always an element of theatrics at trial, and that includes the way a good attorney questions a witness. Unlike debate, the jury is watching attorneys and witnesses to gauge who's believable and what is the truth. On cross, the attorney has to be careful not to violate the jerk rule. It's simple. Don't be a jerk. If the attorney gets too cocky or sarcastic, the jury will start to dislike the attorney and sympathize with the witness, which doesn't help his case. Instead, the attorney should try to play a reluctant seeker of the truth, someone who's just trying to get to the bottom of things by asking pointed questions. This is also true during objections. If an attorney objects to every little thing, the jury might get annoyed or start to think you're trying to hide something. You want the jury to identify with your side, and that means attorneys have to use some finesse.